I just pressed the let's go live button, so let's wait for the stream to fire up all across the fruited plain of the internet before we go ahead and get started. It is a beautiful Monday and a fresh new week, and we can't get started until the tubes are working. And it looks like they are, so let's do it already, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Govea. I'm a criminal defense attorney, and today we are talking about the Trump trial. We've got a couple updates to attend to here. We have the prosecutors who are requesting a protective order in the case. We know the case is being brought by Jack Smith, and there were several filings today that are curious because the prosecutors are now asking for a protective order. They want the judge to impose some rules by which this whole thing will unfold. We've got classified procedures, and Trump's team is going to be wanting access to evidence. And we've already covered a lot of this protective order type of stuff where it seems like there are two standards. Jack Smith and his team, they get to leak to the Washington Times or the New York Post, but Trump and his team, they can't even get access to the documents. Like, he can't even take his notes home with him. So holy moly. So we're going to go through this. We've got a request for the protective order. We've got a proposed order that I want to go through so we can tease out what Jack Smith is saying Trump should be able to do and should not be able to do. And then this is also going to coincide with the length of the proceedings here. And when is this case going to go to trial? Is it going to happen before the election or not? We've got some interesting updates there. Couple clips from Jaime Raskin. He's saying that Trump doesn't deserve a continuance in any of this. And then we'll change gears and talk about this very interesting January 6th case, because this guy, his name is Edward Lang. He is appealing to the United States Supreme Court on an issue that we've talked about here, but it's been quite some time since we talked about it. But we'll go back through it. They submitted their petition for a writ of certiorari with the Supreme Court, saying that there are issues with how these cases are being charged. In particular, saying that they're using one statute to prosecute another type of crime for which the statute does not apply. We'll go through it. It's kind of a technical argument, but I think it is important. And if the Supreme Court accepts this, and more importantly, if they do something about it, this could impact a serious number of January 6 cases. And so it's quite important. We also know the Democrats are literally warning that another coup is coming. And it's kind of a wild thing to hear it. I mean, we all knew that they were going to be doing this, saying that Trump is a continuing menace unless he's jailed, unless he's stopped. He insurrected before, therefore he's going to insurrect again. But Jaime Raskin is literally talking about that now. And we're starting to see these pieces fall into place. He's saying that a good indicator of an oncoming coup is an old coup for which there are no consequences, and they still think that Trump is without consequence. And we start to see other people in the media detailing other parts of the prosecution. So this woman on CNN walks us through this reasonable person analysis. She doesn't call it that, but we're starting to see what the prosecution is going to look like and what the talking points are going to look like. In other words, Trump's mental state was criminal because no reasonable person in Trump's position would have done what Trump did. And so they're kind of testing these talking points out. This was one that hit on MSNBC. We're also going to hear from this woman. Her name is Jocelyn Benson. And if you were here with us when we covered the 2020 election, we spent a lot of time talking about Jocelyn Benson in the months leading up to the 2020 election, because there was a lot of litigation taking place in her state, Michigan, Antrim County, where she was the Secretary of State. And we were very upset about the secretaries of state moving the election rules around. And so they brought her back out, and she's saying that Trump's election lies translated into literal threats. Okay, so free speech, if it's a lie, now becomes an illegal threat that needs to be prosecuted. And we've long said here that I have a hankering, or that's the wrong word. I have a suspicion. Hankering sounds like, I want like a hankering for a slice of apple pie or something like that. But I've got a suspicion that what they're going to be trying to do is create Trump as this new threat that justifies keeping him in custody so that they can hold him in custody. I know it sounds crazy coming out of my head, but all right. I think they want to hold him without bond. All right. and they want to gag him so he can't speak throughout this next election. Because if Trump can talk, then he can defend himself. And so they want to make his words into literal threats so he's gagged or incarcerated. Gosh, all right. So then we've got Fani Willis, the biggest Fani in all of Georgia. I mean, the biggest Fani I know. If anybody knows any Fani that's bigger than Fani Willis, certainly let me know. But as far as I know, the biggest Fani in all of Georgia, she is going to be prosecuting this case against Trump. She's, I think, maybe prosecution 4 or 3. We don't know which one she's going to be. But she's got to bring this case quickly. She says she's bringing it by the end of July. And so now we're asking ourselves, who's going to go first? Is the biggest Fani in Georgia going to go first? Or is that crackhead Jack Smith going to go first? According to Trump, he thinks he looks like a crackhead. So the biggest Fani or crackhead Jack, I don't know. But one of them has to go first. And if Fani's going to be going by the end of July, well, then crackhead Jack must have to go forward. So James Comer has a comment about MSNBC's audience. So stick around for that. It's a funny one. Then we'll turn our attention to what's happening with the whistleblower. We know this week is going to be busy, my friends. So first of all, I forgot to mention this up here, but Trump has a big, Trump has a big proceeding tomorrow, actually, on a lot of this. So tomorrow, Tuesday, is going to be busy because there's going to be a hearing in that case. On Wednesday, there's going to be a hearing with the whistleblowers, the Biden whistleblowers, not this guy. This is Gal Luft, another whistleblower. But Congress is going to have Gary Shapley and Mr. X, who's going to be revealing himself to all of us on Wednesday. And so we're going to be covering that here with a close eye. But something else is interesting happening, because remember, we talked about Gal Luft. This guy is being indicted by the Department of Justice, and he has come out and revealed all sorts of insider information about the Biden crime family based on his close proximity, maybe even involved in the same criminality that Hunter Biden was involved in. And so he blew the whistle. We know that the DOJ immediately unsealed their indictment against him. And now the Democrats are saying that James Comer and the Republicans are colluding with him as a criminal. And they're saying that James Comer has to be investigated now. Okay, so we've got 2 clips of that. Rep. Robert Garcia says, yeah, Comer is literally colluding with somebody who is wanted, a fugitive, by the DOJ. And so James Comer now has to be investigated. We also have Raskin saying the same thing. Basically, Comer is colluding with open criminals. And so this is going to get interesting. Comer is previewing the whistleblower testimony, which is going to be happening Wednesday. Kevin McCarthy promises they're going to get to the bottom of it. So we've got all of that. And then we have an interesting update on this new sort of digital warfare that we're all living through. Zuck wanted to create another honeypot for the feds. Elon took control of Twitter and cut them off with, they got to create an $8 account now, and there's no scraping allowed off Twitter. So the big Intel just gave Zuck a phone call. Can you recreate something that you can give us access to? He's like, no problem. So he spun up Threads, and apparently it's not doing so good. But it also is an entity that is censoring conservatives, as you would expect. It's also censoring liberals. People like Taylor Lorenz also complaining about the new Threads application. And so Jim Jordan, over from the Judiciary in Congress, sent in a letter to Mark Zuckerberg and said, hey, Mark, why are you censoring legal political speech in America in violation of the First Amendment? Are you getting emails from the FBI like you did in 2020, or is this your own accord? So we will go through all of that, my friend. We've got a lot to attend to. And so if you want to be a part of the show, well, we'd love to have you. We have an amazing community where we have member-only morning streams. We had a great conversation this morning, talked about what's going on in some other cases around the world. We like to hit the court docket, in particular some of the Trump cases. And we also attend to the congressional schedule, and we see what the president is up to. We get our bearings straight to start the day. And so we'd love to have you join us. WatchingTheWatchers.locals.com is the place to be. And all members, whether you join us on YouTube or on Locals, don't forget to grab access to the private Telegram group where you can get our chat that never ends. And we had a couple people join up on YouTube this morning, right before the show started. Big welcomes. Patrick Parker in the house became a supporter over on YouTube. So click that join button. Glenda, welcome to Glenda. Welcome Glenda aboard as a supporter on YouTube. And Timothy Teeter in the house, all as members. And so we're grateful to have you. Thanks for joining us on YouTube or at watchingthewatchers.locals.com. We appreciate your support. We try to really deliver for our members, and we got a lot of good stuff coming and cooking too. All right, my friends. Now, we also need to lose some of those leftover pandemic pounds. We are all, I know, sick of the ads for weight loss pills and fad diets and all that stuff. I know we've all been there. We've all done that. We've tried this, we've tried that, and they just don't work. But you know what does? Eating healthy servings of fruits and vegetables every day. I know it's simple, but it's true. You do that, and the weight would probably just fall right off. But look, vegetables, not a fan, and fruit, you know, it's a lot of work to prepare that every day. My strawberries go bad in like 3 days. But we don't have to worry about that. Instead, let's talk about Field of Greens. Now, Field of Greens is a science-backed formula, very specific fruits and vegetables that you won't find in any other product. Proper nutrition reboots your metabolism so you burn calories faster and lose weight the healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you'll look and feel healthier fast, but the greater proof is going to come at your next checkup when your doctor says, wow, you look amazing. You've lost weight. Whatever you're doing, keep it up. And so let's get you started. Head on over to fieldofgreens.com, my friends. And don't forget to use promo code Robert when you check out. Load your cart up with your greens and all sorts of the other good stuff there. There's really a lot. Just go check it out, fieldofgreens.com. And don't forget to use code Robert when you check out. All right. And remember, the vegetables want to be eaten. That's why they burst out of the ground. Look how colorful and happy they are. Look at those smiles on their faces. Make their dreams come true and eat the vegetables. All right. So let's get into it. And welcome, Harley Girl, over on Locals. Welcome aboard. We're glad to have you. Just came over on Locals. Harley Girl, welcome aboard. Super cool. All right, cool. We're growing, baby. We're glad to see all the new faces. We've got a lot of business to attend to. And so we start with this one. Trump prosecutors now request a protective order from the judge. This is the classified documents case that's currently pending in Florida. We've got a lot of questions about this case. We're currently scheduled for trial in like T-minus 3 weeks from now. Is that actually going to happen or not? We know that special counsel Jack Smith has asked to push this thing all the way back to December. We know that Donald Trump and his team want to push this thing off indefinitely. And so we don't really know where we stand yet. Judge Eileen Cannon is going to issue some orders on many of those things very shortly. But at the current time, Jack Smith is requesting a protective order. And we've gone through some other requests from Jack Smith and some other orders here. But they want limitations on what can be done in this case. And this is coming from them. And they're saying that Donald Trump and his team are not really being cooperative. Or they're not really communicating back. And so they're asking the judge to just make some decisions on how this case will proceed. And as we've covered some of these other protective orders and some of these other motions, we have seen that they have, in my opinion, tied Donald Trump's hands behind his back in many cases. In one of the other discovery orders, Donald Trump, as we recall, is not even allowed to take a copy of his notes home with him. Okay, he can take notes, let's say about the police report or about anything else that he sees in his case file, but he can't take those home. They all got to stay under lock and key with his attorney, and his attorneys have all these special rules and protocols that they've got to follow. And so if the defense attorneys and the defendant have to dance and do somersaults and cartwheels for the prosecutors in order to get the evidence, well, that's a little bit of a problem, isn't it? Let's see what Jack Smith and his people are asking for. Pretty short motion here. It's 4 pages. It is the government's response to the... No, this is not the one we want. This is the one we want. This is the United States motion for protective order pursuant to CIPA, the Classified Information Procedures Act. And so this is Jack Smith, the prosecutors against Trump, coming in and asking the judge for protective order. You see, it is a 4-page filing in the Southern District of Florida. The case is against Donald Trump and Walt Nauta. Now, the prosecutors tell us, they say this case involves classified information. Yeah, I know. So it's very dangerous and classified, those 31 documents. Trump was charged with willful detention of national defense information, and classified documents were collected as part of the investigation. And so CIPA applies to this rule because we're talking to this case, because we're talking about classified documents. So they give us Section 3. They say CIPA provides that the court shall issue an order upon the request of the United States. So they're telling the judge, you don't really have discretion on this. All right, the law says if it involves classified documents, if we ask for this, you shall issue an order that does the following: to protect against the disclosure of any classified information to any defendant in any criminal case. They say, in contrast, the discretionary authority of another section of the rule says that when classified information is involved, protective orders are to be issued whenever the government discloses classified information to a defendant in connection with the prosecution. So they're teasing out the rules for us. They're saying, Judge, look, some provisions of the rules say you have some discretionary authority to give us a protective order or not. We're not going to that discretionary provision. We're up here in a different section of the law that says you shall issue an order. If we ask for it, you got to give it to us. On June 26, the court appointed an officer to attend to the classified review of this case. In July, the government sent to the lawyers for Trump the proposed protective order. July 12th, government sends Trump a proposal. Say, we're requesting a protective order here. This is what we're going to give to the judge. What is your opinion on this? And this is ordinary in a criminal case. If somebody asks for a continuance, it's just standard practice to reach out to the other side and say, hey, what's your position on this? Do you object or not? You would put that in your filing. And we've seen that before. Jack Smith says, well, we want to push this case to a December trial date. Trump's people, here was their position. And in this case, they didn't object to that, but they just didn't agree to the December trial date. They wanted something further. So they say here, they sent him a letter on the 12th. On July 14th, so 2 days later, counsel for the defendants for Trump informed the government. They said, oh, thanks for the notice. We do intend to object to certain provisions of the order, but we're not going to tell you which ones. And so the dates on this, let's take a quick look. The 12th was a Wednesday, and the 14th was a Friday. So prosecutors send this over to Trump on a Wednesday. Trump and his team responds on Friday. They didn't specify what they object to. Now, they say the government writes, in an effort to narrow any disputes, the government asked to have a call on July 14th with counsel for Trump and Walt in order to see if it was possible to address their concerns. So they are sending emails back and forth. Can we just hop on a call? Defense counsel informed the government that they were not available that day. Sorry, we can't talk to you on the 14th on Friday. No. But we could find a time for the call the following week. We have other things to do. We're not government employees, and we haven't been focusing only on this case 24/7 for the last 3 years or however long these people have been working on it. So no, we don't drop our actions for an immediate phone call request from Jay Brad. Government counsel responded that the government did not want to delay filing this motion because a protective order needed to be entered prior to the provision of classified discovery. We want this. Before we give you the documents, we're going to have this protective order. And we said, okay, well, the government's going to be available for a call over the weekend, and that it would be helpful for defense counsel to identify the provision that they found objectionable. But guess what? Oh, no. Trump's team, they're not going to work on the weekend, man. And remember, by the way, I'm sure they're working on the weekend, but they're not particularly interested in moving quickly on this case. So the defense is not experiencing the same urgency that the prosecutors are. They're like, hey, we'll talk to you on a Friday, a Saturday, or something. Like, I know, yeah. But it's the weekend, and my son has a soccer game, so I'll get back to you on Monday, bro. Sorry. And until they have, a judge who's encouraging them to hurry this along, there's no real reason to do that. So you can see the prosecutors are getting very frustrated here. Government counsel has not heard further from defense counsel since sending that email on July 14th. Okay, well, the day of this recording is a Monday. I mean, you sent the email on a Friday. It's Monday right now. But is now filing this motion to avoid further delay. Whoa, so like they're angry. Hey, we tried to have a phone call with them, and we sent them this notes and all. The government notes that since sending the proposed protective order to defense counsel, the government has made minor clarifying edits to a few provisions. So they say because the entry of the protective order is necessary in order to provide any classified discovery, the government requests the court require Trump to file an expedited schedule any objections to the proposed protective order. So like Trump needs to respond to this now and let us know exactly what he objects to. because we can't give him classified material until we get this protective order sorted out. And Trump's saying, well, that's true. We're not going to be able to get that classified material. And by the time we get it, it's going to be election season. And so then we might as well not have a trial right now. We might as well postpone that trial until after the election. So they're going to be dragging their feet through this entire thing. No, we're busy. They're probably, sitting in a lounge chair, sipping on Mai Tais, and they get an email from Jay Bratt, the prosecutor. They look at each other. Are we available for a phone call right now? No, we're not available for a phone call. Red button. Bye-bye. We'll get back to you on Monday. And so we'll see what the judge does about it soon. So you can see Jay Bratt very agitated. And they ask that the court enter the following attached order, which is something that we'll take a look at here next. This is the actual protective order. Now, this is 18 pages, okay? So this is the government saying that we want this to govern all of the classified information as this case progresses. They say, all right, we're landing in front of court, in front of your judge, this court in front of Judge Eileen Cannon. 18 U.S. Code applies under SEPA. Pursuant to the authority, under the rules, under the law, they're writing this as though the judge has granted this. Okay, so basically they're giving the judge like a draft, and they're saying, Judge, because this is so perfect and amazing, you're going to sign this exactly as is. And so they're writing it as though the judge is writing it. Now, the judge may take portions of this and reincorporate it back into their final order, but this is just kind of standard practice, is to give the court basically a draft order that the judge could just sign. Because sometimes the judge does that. The judge just takes the order. This is perfect. Motion to continuance, no objection from the defense. Okay, perfect. How far out we going? 30 days? Okay, great. Signed. Boom. Done. Right? It's just done. So they're encouraging the judge to just sign this right now. They say that the court finds that this case will involve information that's been classified and is interested in it involves national security interests. The storage, handling, and control of this information will require special security precautions mandated by the law and require security clearances and need to know and all the different levels. And so the purpose of this order is to establish the procedures that must be followed by defense counsel, the parties, and all other individuals who receive access to classified info and documents in connection with this case. And again, the presumption on this is that the government prosecutors are open and honest and full of integrity, and they would abide by these rules, and we don't need to give them an order. It's just the default. These are prosecutors. They swear an oath. They've got a badge. Whoa. And so we don't need to give them a protective order because they're already going to do things above board. Well, we know that they are constantly leaking inside information about this prosecution and about the character of the evidence to the media on a consistent basis. Happens all the time. I mean, most segments, well, not most, but a portion of the segments that we do here are leaks from the media, from the Washington Post or the New York Times. I mean, we get a lot of the news from the leaks. Otherwise, where would it come from? If it's all really sealed, it would come through the public filings. But all of this always applies to the defense. And if the defense screws something up, they're going to blame the defense. Meanwhile, the prosecutor can leak like a sieve. The procedure set forth in this order shall apply to all pretrial, trial, post-trial matters, and they define things for us. The following definitions apply. What government means. All DOJ prosecutors, law enforcement, intelligence officials, and so on. The defense means Trump and all his people. Classified info means all of these things. Secret, top secret, formally restricted, sensitive compartmented information. Any document or information that is now or formerly in possession of a private party that's been classified. And so we go through the other definitions, mostly covering everything. All right. What is this what is the material that's classified? Everything. Written, printed, visual, digital, audible, handwritten notes, summaries, photographs, worksheets, draft, microfilm, typewriter ribbons, all right, word processing, everything, even information that's obtained orally, if you just talked about it. And so these are the definitions, right? It really encompasses everything. All classified documents or materials contained therein remain classified unless it bears a clear indication that it's been declassified. All access to this stuff shall conform to this order, and Trump may disclose classified information to the defense. The defendants may disclose classified info to the defense as necessary to prepare their defense. Well, that's nice. Any classified information provided to the defense by the government or the defendants are to be used solely by the defense for the purpose of preparing for the defense. It says Trump and the defense may not disclose or cause anything to be disclosed in connection with this case. This is the type of stuff that only applies to the defense. Reasonably believed or known to be classified information except as otherwise provided. Now, I'm not making the argument that the Washington Post is leaking classified information, but they're leaking information about the classified information and about this prosecution, which is supposed to be all under seal to keep the integrity of the Justice Department investigation ongoing, if you believe that's a thing. The defense may not disclose classified information to the defendants unless that same information has been previously disclosed, and the defense may not confirm or deny to the defendants any assertion made by the defendants based on the knowledge that the defense may have had from the classified info. Okay, so I know this is painful to read and listen to, but we're having divisions of what the defense attorneys can talk about with the defendants. So Trump and Walt, right? Trump may know things, in other words, that other people do not know. And so if we're having disclosures back and forth, we're measuring the transfer of information. Who can talk about what? How can they talk about it? Any classified information the defense discusses with the defendants, okay, so like defense lawyers discussing with Trump in any way, shall be handled in accordance with this order. All right. So if Trump's lawyers want to talk to Trump about this, they've got to follow these rules. So there are speed bumps in this case that adversely impact Trump. The defense and the defendants shall not disclose any classified info to any person. Of course, the government does to the Washington Post. Information that is classified that also appears in the public domain is thereby not automatically declassified unless it's officially declassified by the executive branch. If classified information, I was waiting for the penalties. If classified information enters the public domain, the defense, Trump's people, are precluded from making private or public statements where the statements would reveal personal knowledge from non-public sources. They can't comment on the info. If there is any question about whether it's classified, they got to go through the classification officer. They say, in accordance with these procedures, the defense shall seek info from the classified officer if they've got any questions about it. We also have a lot of very experienced prosecutors on this case that they've got all of the requisite security clearances, like Jay Bratt, Julie Edelstein, David Harbach. They say that the defendants, Trump and his team, have a continuing contractual obligation to the government to not disclose any of this information, and they're subject to the court's authority to their contempt power if there is a violation. Individuals with security clearances, right? This is long and complicated. And so if there's a breach of this, Trump's people could be placed in an adverse position. So we'll just fast forward through the rest of this because it's very mechanical. But here you can see record and maintenance of classified filings, separate sealed record for those materials. In other words, Trump is just not going to be emailed a police report. This is going to be a very complicated process. Now, part of the reason I wanted to share this with you is so we could see how complicated this is. And how are we going to get all this done before December? All classified information produced at some point is under the purview of the classified information officer. The defense cannot copy, reproduce anything in any way, shape, or form. The defense shall discuss classified information only within the SCIF. All right. So they have to go to a special room to look at this and cannot disclose any of this information otherwise. So very long, very technical order. And you can see they're asking Judge Eileen Cannon to sign off on this thing, just to say, all right, this is all valid, Judge. You don't have to change a word of this. Sign it. Trump's team needs to comply with it. And so my position on something like this as a defense attorney, although never working on a classified documents case like this, and quite frankly, I don't think anybody in this country ever has, because this is a case of first impression. It's a former president, current presidential candidate being prosecuted for being in possession of what I believe to be his own documents as the former head of the executive branch. But it is incredibly burdensome to the defense to have to do a bunch of stuff in order to even access the evidence. It makes it difficult, but it also is going to give them a bunch of holes and problems in the processing of this case where they can create delays. This was problematic. I didn't get access to that thing. I want access to that. They said I can't. Well, there's a conflict there. What do we look at? The Classified Information Procedures Act. Or what does that say? Well, we got to litigate that. And we want access to that, and they say we can't have it. Judge, I need you to hear this case. Regardless of what happens with that document, it takes time. That little skirmish takes time. Every one of these little skirmishes is going to add an argument or some briefing or some filing. And it's going to delay. So it is a technical filing, but I think the takeaway is that this thing is going to be complicated and that it's going to cause delays. Now, there was another filing that got submitted here. This is the government's supplemental response into the standing discovery order. So the government is periodically filing updates with the court, just letting them know that we're complying with our duty. Remember, in any criminal case, the government has all the evidence. They've got the big case file. In this case, it's like a wheelbarrow full of evidence. And so they've got to disclose it to the defense. We've got unclassified documents in one bucket and classified documents in the other bucket. This is an update on the unclassified bucket. They say, Your Honor, per the protective order issued previously, we gave everybody the first batch, production 1, of unclassified discovery. On July 17th, which is today, of the date of this recording, the government provided its second production of unclassified discovery for the defense. And it includes a couple things: documents obtained via subpoena and evidence obtained via search warrants. Ooh, so it's some juicier stuff on this batch. Memorialization of witness interviews conducted between May 12th and June 23rd of this year, and forms generated by the FBI. So Trump got another batch of stuff, his defense, and that's what it contains. So good stuff. We expect there to be serious challenges to the search warrant and to the raid itself. And if that is the case, if the search warrant is invalid, everything else is fruit of the poisonous tree and it doesn't come in. All of those classified documents they should have never obtained. I think we're going to see a lot of that. Now, the government responds to the specific items as set forth below. This is the government saying we want reciprocal discovery. So whatever the defense has, you got to give it to us. The government is given information that's the Brady material, right? So if anything that is exculpatory to Trump, they've provided. They're also saying that the government has disclosed payments, promises, preferential treatment, other inducements, the Giglio case, and production 1 and 2 of grand jury includes grand jury testimony and other recordings. So Jay Bratt signs this. He says, yep, Your Honor, just complying with our continuing duty to disclose all of this information so that we can assure a fair trial. Give me a break. This is the government standing discovery order, and we have complied as such. So this case is moving along. We know this case is scheduled for oral arguments on the trial date. And of course, once Judge Eileen Cannon issues her ruling on this, we'll know when the trial date is. We know the government wants it scheduled for December. Trump wants it postponed really indefinitely. This is what Jaime Raskin says when he was having a conversation with Jen Psaki.
Also calling for an indefinite delay before he goes to trial. His lawyers are, I should say, in the classified documents case. And Special Counsel Jack Smith's prosecutors argued strongly against any delay. Is there any valid argument for a delay?
I don't think that there should be any delay in an existing prosecution. Otherwise, any criminal defendant in the country would declare for president or Senate or House or mayor and say, you can't prosecute me anymore. You got to wait till next year or the year.
Why didn't I think of that, man? Why didn't I think of that? I could have won every single case. Just have everybody run for office.
After, think of it this way: if somebody is running for office and then is implicated in a murder or a rape or an armed
run
robbery,
for president,
would we say no? We're going to hold that until after the election.
Yeah, just run.
If in the normal course of events it would take place before, he should be treated exactly the way anybody else would be treated in the same situation. There have been hundreds of prosecutions of people on the basis of crimes that took place on January 6th. Why should he be special?
There is some reporting that some of
Jen doesn't even respond. I think even Jen's like, what the hell kind of answer is that? Well, it's about a fair trial. It's about, can you get a fair and impartial jury if it's Donald Trump on there? And I think that Raskin is just equating Donald Trump to every other, common criminal out there, which is something that they want to do, but it's not something that is realistic. I know they live in a fantasy land, but the reality is, in America, we have something called the presumption of innocence and due process and equal protection of the law. And so the defendant deserves a fair trial. And that means that you got to have a fair jury. And the question that we have, that even the Justice Department has, is can you have that, or do prosecutions impact elections? Obviously they do. Even the DOJ won't bring charges within a certain period of time, lest it impact the outcome of the election. But Jaime Raskin, has a difficult time with complicated things like the Constitution and the law. But we know Jack Smith is continuing forward. We're waiting to see what Judge Eileen Cannon does in terms of scheduling a trial date. We will continue to cover, and I hope you join us as we do. All right, my friends. Now, we know that Jack Smith is charging Trump in Florida and very likely elsewhere. But there is another prosecution that is moving along. January 6th defendant Edward Lang submits a petition for a writ of certiorari to the Supreme Court of the United States. And if he's victorious on this, it's going to cause a lot of consequences, good consequences, for many J6 defendants who have been improperly charged after the January 6th riots. We're going to go through this story. This is the petition that Edward Lang submitted into the Supreme Court. We'll read through it. Not a long petition, only about 29 pages, but it has some good inquiries about what the DOJ is doing. For some background, let's go over to Newsweek. They say that this case could upend hundreds of Capitol riot cases. It says a new petition in the Supreme Court, the one that we are going to read here in a short minute, could upend hundreds of cases related to the January 6th Capitol riots if the court hears it. Edward Lang, the man who brought this case, was arrested, charged for his role in the riot after he posted photos and videos on social media placing him at the Capitol. The charge in question against Lang and others has been deployed against hundreds of defendants, including QAnon shaman Jacob Chansley, the Oath Keepers founder Stuart Rhodes, former Olympic swimmer Cleet Keller, and others. The charge was also cited by the House committee investigating the riot that issued criminal referrals against Donald Trump, right? The official proceeding refers to Congress's certification of the Electoral College votes that elected Joe Biden. And so let's take a look at this. It's a little bit of a technical case, but I think we'll be able to get through it relatively quickly. Not a long filing. It is 29 pages. This one goes to the Supreme Court of the United States of America, Edward Lang versus the USA. You see, this case is brought by Norman Pattis. We've heard of him before. We heard from him in the Proud Boys trial, along with Stephen Metcalf, also from the Proud Boys trial. Here's what they are asking the Supreme Court. They say, "Dear SCOTUS, we've got a question about whether the Court of Appeals entered an erroneous ruling. They concluded that the law, which is 18 U.S. Code 1512, which is a statute that was written, it's a criminal law that prevents tampering of evidence. They're asking, does that law that prevents tampering of evidence, can you use that to prosecute violent riots? Are you allowed to do that, resulting in a misapplication of the statute? Can you use like a shoplifting statute for car theft? Yeah, they're kind of the same, like it's something sort of, but are they close enough? Or should you use the car theft statute and the shoplifting statute? So they're saying that there's a misapplication here. The DOJ is using a broad application of this law so that they can do whatever they want under it and get a boatload of new charges under this provision, Section 1512C2. So they're asking the Supreme Court to clarify this for us. We know that petitioner Edward Lang is currently incarcerated along with many other J6ers, and there's other cases involved. And so we'll fast forward directly to the opinion. They say that the Fifth Amendment to the United States Constitution says the following: no person shall be deprived of life, liberty, or property without due process of law. And another provision of the law, which is not in the Constitution, but which is in the U.S. Code, says the following: it is illegal that whoever corruptly, okay, this is the law, whoever corruptly, and this is a very important phrase, because what does that mean exactly? Whoever corruptly alters or destroys or mutilates or conceals a record or a document or attempts to do so with the intent to impair the integrity of that document or its availability for use in an official proceeding, that's part one. If you do that, you broke the law, all right? Or you could do this. You could do one or the other. If you corruptly alter or destroy a document and impair that document's ability to use in an official proceeding, guilty, right? So we're asking ourselves, is attacking a police officer impairing an object's document so that the document is not available for a proceeding? Doesn't seem right. Or how about this one? Another provision of the same law says, whoever corruptly otherwise obstructs, influences, impedes any official proceeding or attempts to do so. Well, that might be closer. If you're a J6 insurrectionist and you're impeding any official proceeding or attempts to do so, maybe that one fits. So let's go through this. But again, corruptly applies to both of these. All right. If you do something not corruptly, then neither one of these will apply. And we have the or here, which makes it's one or the other. So we see the statement of the case. This is the defense writing. In the appeal to the Supreme Court, they say, a short walk from the building in which this court sits, a revolution is underway, with ambitious federal prosecutors reworking the criminal code to make it do work never intended to be done. Work that threatens to chill, and does chill, ordinary Americans in their First Amendment rights to assemble, to petition for a redress of grievances, and to speak out on matters of public concern. These attorneys say, in the name of saving democracy, prosecutors are undermining the core principles on which this republic stands. In this case, likely the first writ of certiorari filed incident to a criminal prosecution arising from the events of J6. The petitioner requests relief to check the blind ambition of federal prosecutors. Stop those prosecutors from doing this, Judge. Without action from this Supreme Court, hundreds, if not thousands of Americans will face substantial prison sentences for doing no more than speaking out at a protest that evolved into a dynamic conflict. It is no overstatement, Supreme Court, to say that the future of the First Amendment hangs in the balance. A statute intended to combat financial fraud has been transformed into a blatant political instrument to crush dissent. The attorneys say, on January 6, 2021, thousands of Americans gathered in D.C. to protest a stolen election, as direct a threat to our democratic traditions as a foreign invasion. They were inspired to attend and to protest by the President of the United States, Donald Trump, who in the aftermath of 2020 contended the election was stolen to the benefit of then President-elect Joe Biden. Mr. Trump urged people to come to D.C. to, quote, stop the steal. It was the day Congress that was statutorily obliged to certify the results of the vote, when it became apparent that Mike Pence, not my concern, the presiding officer of the joint session of Congress responsible for certifying the results, would not act to stop the certification. Mr. Trump urged thousands milling about on Washington's Mall and at the Ellipse, where the president was speaking, to head to the Capitol and to patriotically and peacefully protest and to, quote, fight like hell, lest they no longer have a country. The president told people the republic was under attack and that ordinary people needed to save it. And so the petitioner, Mr. Lang, sitting in custody, he heeded the president's call to action. He went to the Capitol to protest. He was swept up in the violence of the crowd and the ensuing struggle with police officers, where he acted to defend himself and others from police violence. He is among the more than 1,000 persons to be arrested in the wake of the riot at the Capitol that day. And he acted in self-defense, in defense of others, and in the defense of democracy itself. Among the charges he faces is a violation of U.S. code. They say he acted with, quote, corrupt purpose to impede an official proceeding. The DOJ promises as many as 1,000 more prosecutions coming. 1,000 done, 1,000 more to come. Still an embarrassingly low number for all of these resources. Save that for a later conversation. This statute has been used repeatedly in these prosecutions of those accused of breaking the law on J6. So they ask the Supreme Court, they'd say, Your Honors, use of a statute intended to combat alteration of records, intimidation of witnesses, and conduct aimed at disrupting proceedings is an example of prosecutorial overcharging, using a statute that was designed for one purpose in a manner at odds and inconsistent with the congressional intent and the plain meaning of the statute. This is a documents crime, not an insurrection crime. So you're not allowed to use it as an insurrection crime. This use necessarily chills anyone considering a public protest or appearing outside a building where there's an official proceeding. Will they also show up and be charged with a felony if the event turns violent, they ask? So they tell us that Mr. Lang originally filed a motion to dismiss this one count. He wanted that one count gone. And you know what? Mr. Lang won on that. The lowest level court, the district court, actually granted the motion. And so the government said, what? They appealed it, took it up to the Court of Appeals, and they issued a split decision. They reversed the district court. Lower level court says, yeah, government can't do this, okay? They're charging you with a protest crime under a document crime statute. The statute is not written for that. You can't do that. So the government appealed it, as they always do, and the Court of Appeals reversed. But they issued a very strange opinion. Mr. Lang now asks this court to grant certification because there's a very complicated question here. And this question is going to arise in hundreds of cases as the DOJ continues to charge folks who participated in a protest turned violent. And resolution of this question is imperative to prevent the use of this statute to prosecute folks, keep using the folks word, who protest in a good faith belief that their actions were necessary to prevent the election from being stolen. An event tantamount to an internal coup d'etat. Refusal to resolve this question will chill others inclined to petition and assemble for a redress of grievances, and for fear that those opposed to their views might prosecute them for this, possessing a corrupt intent. Here's the argument. They say, hey, Supreme Court, prior to the trial, the district court actually granted the defendant Lang's motion to dismiss. The government appealed it, and they reversed. And so the sole issue right now, Supreme Court, is whether the indictment that Mr. Lang is facing and the crime under which he has been charged, whether it violates what is called the breathtaking standard under Van Buren versus United States. Two questions. One, whether the law is subject to an evidence-based interpretation, saying, in other words, does the assault on a police officer match the statute? Can we just look at the evidence and does it match? We're going to ask that question and do some analysis on it. Did Mr. Lange's conduct look like it was impeding a document? And second, whether the corrupt element applies. What does corrupt mean? Almost means like getting a benefit for yourself. You're going to sign this document so the money goes into your bank account, right? Or something. And the question is, did Mr. Lange have a corrupt purpose? Can that be satisfied if Mr. Lange didn't get anything from the misconduct? He says, no, it cannot be satisfied. So those laws don't apply to me. It's not an actual document crime, and I didn't do it corruptly. It was a protest. And when this got to the Court of Appeals, they offered vastly different opinions. So they say, we don't even know what the standard is. We had different interpretations here. And I want to fast forward through this, but I want to just highlight this so you see it. Writing for the court, Judge Pan read the section very broadly. He concluded that corrupt mental state encompasses any unlawful purpose. All right, so anything that you do is corrupt if it's unlawful because you're breaking the law. And they say, wait, well, that basically means the statute, like that word would be meaningless then. If it's any violation of the law, it almost sounds like it's kind of strict liability type of a crime. If you just do this thing, you're guilty. But the mens rea, the mental state, is corrupt. So were the January 6ers, in this case, Lange, was he acting with a corrupt purpose? There was another concurrence. Judge Walker said something different. Concluded by reasoning, saying that the benefit was to President Trump. And so another judge thought it necessary to define corruptly. Okay, so they're all defining corruptly. There was another person in a dissent. And so we've got all these disagreements. Nobody really knows what the application is. So they are asking the Supreme Court for clarity on this. This is an issue of vital importance. If not hundreds of defendants who are being prosecuted here, we're all left without guidance from a fractured court. The judge writes for the court, says there's a broad definition of corruptly, which means any unlawful purpose, and rejects evidence-based limitations on prosecutions. But Judge Walker implicitly rejected that, but adopts a narrower definition of corruptly, one in which there is an unlawful benefit. And then Judge Katsas adopts another limitation, and he says, look, this is a cacophonous result, and it leaves unsettled very significant issues, which is why, Supreme Court, we need you to get in here. If you don't get in here, there's going to be a discordant series of appeals and petitions to come. Everybody's going to be appealing this. It's going to be a total nightmare. So, Supreme Court, you've got to hear this. They say this prosecution at issue here arose in unique context and at a fraught moment in American history. A sitting president claimed an election had been stolen. Short of an invasion by a foreign power, the most shocking threat conceivable to the American Republic. The president called upon Americans to come stop the steal. On January 6th, the day the votes count, thousands showed up. But a riot broke out. Hundreds, perhaps when all the charges that can be filed have been filed, thousands of Americans are going to face criminal prosecution on this. All attended an event to petition for a redress of grievances. All assembled, all intended by their presence to speak out. That's what they were there to do. That is lawful. That is not acting with corrupt purpose. That is a constitutionally protected right. A wide variety of criminal charges, both misdemeanor and felony, cover the panoply of offenses committed that day. But for reasons unknown, the Department of Justice has seen fit to apply a statute applicable to crimes involved in the presentation of evidence at official proceedings done for venal and corrupt purposes in a manner that has never been done before. And so it falls on this Supreme Court to rein in the Department of Justice. The deterrent effect of criminal prosecutions must not give way to vindictiveness. Using this law in this manner and in this context will serve only to chill people in the exercise of their rights, the rights that are fundamental to our way of life. They talk about the law again and the judge's dissent. They say the government in this case has made a policy decision to broaden the application of the statute. They want to over-penalize those who participated on January 6th. Until the prosecutions from J6, it was uniformly treated this law as evidence impairment crime. But until J6, courts had no occasions to consider whether they could use this more broadly. And they did, because they want this thing to sting. They want Stuart Rhodes, who got 18 years, to serve much more time. They say in this case, Supremes, protesters turned out en masse to engage in a protected activity. They petitioned for a redress of grievances. They assembled, and some engaged in vitriolic, hyperbolic speech, both on the day of the protest and in the weeks preceding it. When the demonstration turned into a riot, some of the protesters turned to violence. Mr. Lang will contend at trial his use of force was in defense of himself and others from the police violence. There was no need to create a new and novel application of a statute to capture the violence that took place that day. Existing statutes took place, and they are sufficient for criminal liability. Did Mr. Lang assault a police officer? If so, there's a statute for that. Did he breach the peace? If so, there's a statute for that. Did he trespass? The answer is by now obvious. There's a statute for that. It's like the app meme. They should use the correct statutes to prosecute people. They shouldn't be overly applying statutes that don't. But unsatisfied with the penalties, they didn't like the penalties. They wanted more crimes. The violation of these statutes might impose the desiring to broadcast a general and more compelling general deterrent message. The government then transformed the law into something well beyond what Congress ever intended. It was for evidentiary proceedings. And this statute not only carries with it a significant penalty, 20 years in prison. That's why they want that one. It sends a chilling message to anyone contemplating attendance at a rally. Don't even think about it. If you show up there, if things go wrong, you could face charges of corruptly obstructing an official proceeding. And they talk now about the corruptly provision. This is more than mere intent. If the term is more than mere surplusage, it's not a surplus, is the point. This is an element of the offense. The word corruptly means something. And so these lower court judges, they skirted the issue. And we need to know what the law means and what the law says in order for the law to be constitutional and apply. He's giving us some compare and contrast. Now we get to Lang. He says, Lang moved to dismiss the indictment as to this count. He says this statute was applied to him in a breathtakingly overly broad manner. He says the statute is designed and intended to prohibit tampering with evidence, and it doesn't cover a violent assault against the police. The district court agreed, the Court of Appeals didn't, and so now we're asking the Supreme Court to give us some clarity on this. He's going through the other judges' opinions and teasing out the problems. But he concludes, he says, in sum, the government's decision to charge Mr. Lang here is an example of prosecutorial overreaching. The federal statutes were not silent on the claims the government wanted to pursue at trial. The government contends he assaulted police officers and disrupted Congress. Lang contends otherwise, but he understands that his right to present a defense must wait until the time for trial. For the present, he can only ask this court to reverse the Court of Appeals, saying that there must be evidence of this charge and that the corrupt intent just doesn't apply here. It says that it is the regime that stops this, that stops people from petitioning for a redress of grievances, that is a real threat to democracy in America. And so they say, Supremes, this is ripe for you. We need your take on this. This was drafted by Norm Pattis and Stephen Metcalf, both great lawyers. We've covered many of their efforts here on this channel when they were representing the Proud Boys in that case. They're saying the Supreme Court, there is nothing here that is appropriate. This is nothing less than the weaponization of the penal code to stifle dissent. It sets a terrifying precedent unworthy of this nation's history, and it must be addressed. So the case is Edward Lang in the Supreme Court of the United States, petition for certiorari. We'll see what the Supreme Court does on this. I do think it is something that needs to be addressed one way or the other. And as more of these cases go to trial, we're going to see more appeals on the verdicts. And Section 1512, I think, will come up again. So the Supreme Court may have to resolve this one way or another. We'll see if they pick it up now. And of course, we'll continue to cover, see what happens with Mr. Edward Lang and all of the other J6ers as the prosecutions continue. All right, my friends. And so we move on, and now we go back to another warning from the Democrats. Here we go again. Democrats issue another warning. There's a coup coming. We already had one, and now we might have another one. And so we've got Jaime Raskin and others who are laying the framework for what I fear is going to be their attack strategy against Donald Trump. If Donald Trump caused an insurrection already and they prosecute him for that insurrection, they're going to say that he's going to do it again. And just like somebody who breaks the law repeatedly, courts don't let those people out. And so the Democrats are going to say Trump needs to be incarcerated or gagged or severely limited lest he insurrect again. They say he's going to be running again. And if he loses again, he's going to deny it again. And that justifies the DOJ and the courts doing something pretty serious. And this is not an isolated thought. There are many people now saying that Trump's conduct is essentially an ongoing crime and that the old coup is just evidence that a new coup is coming down the line.
Tonight, Kari Lake in Arizona continues to lie about the election. Donald Trump continues to lie about the election. And in truth, no one has faced the consequences about lying about this election and undermining democracy.
Well, the political scientists will tell you that the single biggest predictor of a coup coming is a recently failed coup, where the coup plotters are able to determine what are the weaknesses in the current regime that they can exploit next time and what mistakes they made that they can correct in order to orchestrate a similar attack.
So they're probably going to have to hand off the podium next time. They're going to need like a relay race. So podium guy is going to have to give it to somebody else, and then he'll have to hand it off to somebody else in order to actually take control over the country, I think. Or I don't know what the plan is.
In the future. And it's also the case from very clear historical studies that when an insurrection takes place, an attempted coup takes place, and there is not a complete, full accounting of what took place in a repudiation of the coup, that gives greater impetus to the coup plotters to go out and do it again. So this is a critical issue when you've got Donald Trump's followers running around the country saying either Antifa did it, or it didn't really happen, or it's been overblown, or it was all a government plot. And, that's why it's great that people are standing up across the board to challenge the big lie and all of the other lies, the medium-sized lies and the little lies that follow in its train.
Amazing. So that's Raskin. Another coup is coming, and everybody basically better prepare themselves. This is the subscription service coup plotter plan. Every couple of months they come out. Trump's going to take over the country again. Make sure you donate. Trump's going to take over the country. Make sure you donate. We're going to go through a coup again. Support the FBI. Support the Democrats. And so around and around we go. But I think it is more serious than that. They're actually going to try to limit Donald Trump in what he can do and say. And why I think that is because other people are saying that Trump's lies turn into actual threats. This is Jocelyn Benson. She was with the state of Michigan, and we spoke a lot about her when she was the Secretary of State back during the 2020 election, because there was lawsuits flying all over the place in many states. Michigan was one of them. And we were concerned that the election laws were being changed outside of the purview of the state legislature, because secretaries of state and judges and lawsuits brought by people like Mark Elias were nudging the rules more towards waivers, extension of deadlines, mail-in balloting, and all the things. And she was at the forefront of this in Antrim County and some of the other stories we covered in Michigan. And now she is emerging And we hear from her how dangerous Donald Trump is.
And what did you tell Jack Smith's investigators?
I can't, as I've said, I don't want to compromise the investigation itself, but a lot of what I've said is already public through my testimony to the January 6th committee hearing before Congress in 2022. So a lot of the focus is on Antrim County. We know that a lot of the experiences that we had were about how lies and threats transformed themselves and manifested themselves. I'm sorry, how lies around our elections transformed themselves into threats against us personally and how that impacted us.
Good, much better.
And not to mention the false slate of electors, which appears to be a very intentionally coordinated effort to lie to the federal government about who won an election.
Oh, we saw a couple little sound bites there. So for the first take on that was not that good. And she had to take two takes on that one. Donald Trump's lies turned into election. Sorry, I screwed it up. So let me start that over again. What I meant to say is Donald Trump's lies almost turned into murder for me. What I meant to say is Donald Trump almost murdered me. Okay, and the producers were back there like, got it. All right, good. Got it the third time. Yeah, more of that. Well, a lot more of that. Trump's lies turn into actual threats. She nails it. She's like, woo, got it.
In 2022. So a lot of the focus is on Antrim County. We know that a lot of the experiences that we had were about how lies and threats transformed themselves and manifested themselves. I'm sorry, how lies around our elections transformed themselves into threats against us personally and how that impacted us.
Much better.
Not to mention the false slate of electors, which appears to be a very intentionally coordinated effort.
See that there? The false slate of electors is going to be the other angle on this. That's the intentionality. That's Trump not accepting the final conclusion and then now coordinating and reorganizing to seize power in the country. So she might even be a witness, right? She might be somebody who comes in and testifies in some way, shape, or form, depending on some of the pressure that was, maybe put on her county or whatever, or her state.
To lie to the federal government about who won an election.
Yeah, amazing. So we know where this is going. They are gearing up and they're just putting their pieces in place. Trump and his lies turn into actual threats that put her at risk and that may have broken the law. We'll see what Jack Smith does with it. Now, this is another woman over on CNN. And she's going to walk us through this reasonable person standard. This is something that exists in the law. We often will zoom out on cases and we'll ask ourselves objectively, did that thing that a person do, is that something that a reasonable person in that person's position would do? You often see this like in self-defense cases. Would a reasonable person have taken that out and defended himself in that way? And you say, well, yeah, it's reasonable. Why? Well, because that guy had a knife and he was coming at him and all the things. So we're asking ourselves, would Trump be a reasonable person to deny the outcome of the 2020 election? Is there any basis in that? She says no. There's no reasonable basis. No reasonable person could ever believe what Trump did.
I see it, I receive it, but legally speaking, what would be the consequence of him really believing that he won the election?
Well, look, this as a former prosecutor. I know this as an attorney. It goes to the state of mind, right? So that's what he's trying to probe. Did he really believe this? Thus, did he lose his mind? Because honestly, he would have to not been in his right mind to believe that he won an election that he clearly lost, right? Aides were telling him that he lost the election. You have texts from Fox personalities and others going back and forth on January 6th about he needs to shut this down. You opened with Cassidy Hutchinson and her testimony, which I think was devastating, right? And Mark Meadows and how they felt about the president's state of mind before January 6th and otherwise. Chris Christie has talked about it, right? Many times on the campaign trail. So I think that there's no way he believed that he won that election. I think he decided he was going to take the election and overturn it.
That's the line that they're going to have to cross. And it's pretty amazing that she just jumps to the conclusion that Trump could never have believed the alternative, which is amazing because we sat here believing the alternative, and I like to think we're somewhat reasonable here. But we saw all sorts of other mounds of evidence that showed that the election was highly problematic, and we covered it here. We covered the lawsuits here. Now, the fact that a judge wasn't willing to reverse an election doesn't mean that there were constitutional problems with it. And there are court filings that support that. And we could point to many of them where the state legislatures were usurped by the secretaries of states and the courts in various different places that mattered, like Pennsylvania. So this is interesting. And I think as the time goes by, as the story evolves, we find that there's even more evidence, as now we know that Secretary of State Anthony Blinken colluded with the CIA director, Mike Morrell. They created the 51 Hunter Biden laptop excuse cover-up letter, and they shoved that down all of our gullets, along with the FBI putting pressure on Facebook and Twitter to suppress conservative speech, to stop anybody who is speaking out on behalf of Donald Trump. And the list goes on and on. So it is, I think, entirely reasonable for Donald Trump to be in the position that he lost the election and to pursue that as far as he can take it. We live in an adversarial system where you're allowed to do that. And that's exactly what he did. And it went all the way up to January 6th, and Mike Pence went in there and did what Mike Pence did. And all of that is legal. They may not like it, but it's Trump believing thoroughly in his heart that the election was lost and that he was pursuing every available option till the end of time. That is not criminal. They're trying to turn it into a criminal by saying no reasonable person would have believed that, but that's her position on that. I think there are plenty of reasonable people who saw the votes. We were watching them here all go like this, and then boom, all the mail-in ballots and everything suddenly changed. And it was a very strange affair that gets stranger by the day, but they're going to try to make this criminal now, okay? That Trump believed that. They're going to try to backfill this whole thing. And I think personally that the days that go by, Trump's position becomes more reasonable, not less.
And if you really go back and look at Trump's rhetoric, starting as early as before the conventions of 2020, he was leading up to that about, well, I don't pledge to accept the results unless, I have to see. There was this wishy-washiness, right?
The hedging of if it's fair.
Giving myself this plausible kind of deniability out that, well, I don't want to box myself in like every other ordinary person who runs for president says, yes, if I lose the election, I congratulate the other person and we do a transition and we move forward.
But that's the word that I hone in on, plausible deniability.
There it is.
Because in the law, one has to have some plausible basis to believe that statement in terms of the intent. It's a very difficult thing to prove, though. And I wonder, do you agree with what Jim talked about, that the fact that Kushner, Hope Hicks have been now questioned, that makes this that much closer to the maybe beginning of the end?
Well, Laura, he would be derelict in his duty as the special prosecutor if he didn't go into that inner sanctum sanctorum, right, of people who would have had conversations with the president on election night, after the election day, and get to his state of mind. So I think he is closing the loop. I agree with your earlier guess about that he's winding this down to bring an indictment.
They want somebody to come out and say, I talked to Trump, and Trump said, I know I lost, but we're going to take it anyways. I know Biden won, but can we do this? They're looking for somebody who can thread that needle, and they might find somebody. They might make somebody up. We know who we're dealing with here. But the clock is ticking. We have a timeline to attend to, and we know that Jack Smith has been hinting that a January 6th prosecution would be coming any minute now. We've read through many leaks from the New York Times and WAPO and all the other places. It should be soon because they want to get the trials done quickly. They're already fighting to get the Florida case trial done by December. And so if they have a DC case, they're going to want to get that one done quickly too. And the longer they wait, the more this encroaches into election season, which will then make it more difficult to have the trial right in the middle of that era. So now we know Fani Willis, the biggest Fani in all of Georgia. I don't know anybody bigger than this Fani. And she is about to prosecute Donald Trump, she says, by the end of this month. And what does that mean for Jack Smith? Does that mean he has to accelerate his case? Because it is very similar, a lot of overlap. Here is the report.
Federal prosecutors do not exactly love when parallel local investigations outpace their own. They want their evidence and their theory of the case to be the first version that the public hears. So DA Willis poses a problem for special counsel Smith. DA Willis has signaled that she anticipates announcing.
Fani, yeah, the biggest Fani here. biggest Fani in all of Fulton County. I don't know anybody who's a bigger Fani than Fani Willis. She's the state attorney. I mean, that's big. Like, you got to be a high up person. Fani Willis is the biggest Fani in all of Georgia. So you can see the timeline on this. July, August, we are nearing the end of July. And so Fani Willis indictment likely, they have the green arrow that comes all the way up to the 18th of August. But it could be as soon as July 31st when the grand jury is being impaneled. So it's coming up. And so if Jack Smith is going to increase or going to bring his indictment first, it's going to be coming soon, like in the next 2 weeks.
An indictment potentially as early as July 31st. That gives Special Counsel Smith 11 business days to make his own announcement, assuming he wants to make it first. And that is not the only calendar that Jack Smith has to worry about. There has been endless speculation about what the 2024 presidential calendar will mean for Smith's prosecutorial decisions.
Coming up.
And today, we finally heard about the matter from the man himself.
Yeah, he filed a motion. We already read that motion. It was a motion for a protective order and a motion for a response to Trump asking for an indefinite continuance. And so we heard about all of that, but they are assembling the talking points, warning that another coup is coming because the Trump indictment is right around the corner. And here is James Comer explaining what he thinks about MSNBC and their audience.
They know this family was money laundering. They were profiting off Joe Biden's influence. The media knows that, but they're just not covering it. Then you have the liberal media like MSNBC with their low IQ audience that are sitting there and they're being told bad things about me and members of the oversight committee because we have the audacity to investigate.
Yeah, not too bright over there. But they do say that there is another coup coming, and I think it's just something to keep their audience engaged and donating and voting. And this is the new campaign. They're not going to be running Joe Biden on a new vision for America or a track record of accomplishment. They're running Joe Biden on the back of the DOJ prosecuting Biden's political opponents. And every day that they can wake up and press that fear button that Trump is going to coup again, it's going to be a good day for them. So there'll be a lot more of this. Of course, we'll continue to cover. And thank you for subscribing, my friends. Wherever it is you're watching this, we're going to be watching closely and waiting for that next coup. And I'm just joking about that for the FBI out there. All right, so let's continue on. Democrats now want to investigate James Comer. James Comer is getting a little bit too close for comfort. He has the Biden whistleblowers testifying in front of Congress. He's also had contact with this guy, Gal Luft. Gal Luft apparently has got a lot of evidence about Biden crime family criminality because he may have been in the transactions right next to Hunter Biden. They were both apparently working with CEFC, a Chinese energy company. And so now that Gal Luft has come out and exposed the Biden crime family, the DOJ is prosecuting him. They unsealed their indictment, and now the Democrats are saying that Comer colluding with Gal Luft is Comer colluding with a criminal, and that now James Comer, a sitting member in Congress, needs to be investigated over this. And so we see that the escalation just continues on and on and on. Before we know it, Congress is going to be prosecuting each other or sicking the DOJ on each other, even though, of course, they're Congress people with legislative immunity. But this is the level we're getting to. Hunter and Joe and the Biden family create a bunch of crimes. Somebody blows the whistle on them, and the Republicans are the bad guys for colluding with the whistleblower. That's the Democratic mindset we're going to listen to. Here is Representative Garcia. This is him explaining this take.
That's exactly right. I think first, let's be very clear. There has been zero evidence linking the president to any sort of mishandling or crimes as it relates to all these accusations that the Republicans have been throwing at them. What is very apparent is that this informant, who has apparently been working at some level with either Chairman Comer or committee staff and other Republicans, and I think, we've had Marjorie Taylor Greene and others also hype up this informant as very credible.
Marjorie too.
When we know he's actually a criminal that's likely selling arms to our adversaries.
Hey, what about the presumption of innocence there, buddy?
And so this deserves an investigation. We should be investigating James Comer and his actions here. And so I think what's very clear is that James Comer is only interested in going on Fox News and serving as Donald Trump's spokesperson. He's doing the bidding of the Donald Trump campaign. This whole agenda about trying to take on the president for doing absolutely nothing and attacking the president's family, conspiracy theory after conspiracy theory, they continue to be debunked. And so he's doing the bidding of the Donald Trump campaign on the taxpayer dime.
So would you support releasing all of those FD 1023 documents and the other FD documents? They'll clearly exonerate Hunter and Joe, right? There's nothing here. So why don't we take a look at all of the materials?
And it's not acceptable. So those of us on the House Oversight Committee are going to continue to push back every single time against these lies and this complete waste of taxpayer resources. And by the way, Michael, we're going to see it again this week. James Comer apparently has more quote unquote whistleblowers that he's going to bring to the Hill to go on and on about crazy conspiracy theories. It's the same thing over and over.
So now the Democrats are literally threatening their colleagues in Congress with investigations, maybe by Congress, maybe by the FBI, maybe by the DOJ, all because they're exposing his team's criminality. That's what these people do. They want to censor you off of Twitter or off of Facebook, get you strikes on YouTube, whatever they can do to silence you. And if you're even a member of Congress, you should be investigated. And it's not just Garcia, it's Raskin too.
What information are you seeking about James Comer's involvement with Luft, and what do you really want to know?
Well, look, Gal Luft was supposed to be the star witness in arraigning Joe Biden on the old Giuliani charges of a fake Ukrainian bribery scandal. And it turns out that Luft was missing, as Chairman Comer kept saying. The reason he was missing is because he's a fugitive from justice. He's on the run around the world away from the U.S. government. And this was going to be the star witness against Joe Biden. And what I'm afraid has happened, Jen, is that the Trump party has created such a topsy-turvy world that we're getting real low-life characters like George Santos, like Donald Trump, like Gal Luft, who say, I think I'm going to be able to launder all of my crimes and wrap myself in the production of the Republican Party.
They see targets of people they could go after to help them.
That's right.
And so how concerned are you that James Comer was the chairman of the committee, was knowingly, unknowingly
colluding
with, co-opted by a foreign agent?
Yeah, I'm just concerned that the House Oversight Committee, which has a very proud history with, Congressman Waxman as chair, the great Elijah Cummings of Maryland as chair, is suddenly being compromised in a really serious way. Our legitimacy is being eroded by the tactics adopted by Chairman Comer. They essentially have said, we will validate anybody who will say anything about the Bidens. And of course, they haven't laid a glove on President Biden. There are real issues that are confronting our people, and they're off on this wild goose chase related to Hunter Biden and Joe Biden. And their main witnesses are people who are fleeing justice in America.
Yeah, because they're being prosecuted by your corrupt DOJ, your enforcers who don't even allow the Biden name to be brought out during trials are covering for the Biden crime family. Obviously, Gal Luft is not going to come back because the DOJ is a corrupt, garbage prosecuting agency. So is the DC Circuit Courts. He knows that, so he's not going to come back. But Raskin will continue on this fantasy that Joe Biden is as clean as the wind-driven snow, and the only person who's really corrupt here is James Comer. Never mind Hunter Biden. Has he even seen the laptop? Has he even any idea what's on there or what was involved here at all? Seems like he's just in a deluded little world, and Jen Psaki is happy to indulge him, unfortunately for her. So we've got reaction to this. James Comer says the whistleblowers are testifying soon. These people are very credible. In fact, 2 of them have come from the IRS, and there are new rumors today that apparently an FBI agent might also be emerging as somebody who's going to corroborate the whistleblower's claims, as somebody who may have been on that team. More will be revealed on that one. But here is Comer explaining more about what's happening with these whistleblowers coming up shortly.
Well, we've learned, obviously, there have been more bank transactions. this family's been receiving money from all over the planet. I think everyone knows that watches Fox News, but unfortunately people that get their news from other outlets aren't as educated on it. So Wednesday, we're bringing the whistleblowers in. These are very credible career IRS employees who have never blown the whistle on anything. One is a very partisan registered Democrat, so we're excited that it's going to be a bipartisan panel. We're going to be able to ask them very specific, substantive questions about crimes that have been committed by various members of the Biden family. There's a lot of talk back and forth about, well, they should have been charged with money laundering, or they should have been charged with wire fraud, or they should have been an unregistered foreign agent. What level of tax evasion did they really have? We're going to be able to dive into that in a public setting where every American is going to have the opportunity to watch this hearing live.
Good.
And I think that the American people are going to be very satisfied with the answers that we get. And I'm excited, Maria, because we found all these shell companies that make absolutely no sense. I don't believe they've paid a penny of revenue, a penny of taxes on most of this millions of dollars that they've received from our adversaries around the world. But then the question is, what did they do to receive this money? How did they list that on their taxes? As a service they provided, as a capital investment? We don't know. So if you're into finance, like most of your viewers are, this should be a good substantive committee hearing that will allow us to move forward in the deposition process when we bring these individuals that were helping the Bidens funnel and launder this money. We'll be able to ask them specific questions about specific transactions.
Have you been able to identify specific policy decisions that Joe Biden made as a reason to get paid? For example, he came into the White House at the beginning of his term and he canceled the China initiative, which was an initiative to indict people who were sending information to the
Also,
CCP
the
while
Ukraine
they surveilled us and spied on us. Was he paid for that decision?
And the Ukraine prosecutor that got fired.
You look who President Biden had go in and advocate for that was the then president of the University of Pennsylvania, who he's now made an ambassador to Germany. But remember, what we've learned is University of Pennsylvania was the recipient of tens of millions of dollars of anonymous donations from China. So who better to go and advocate to abandon the China initiative, which was an FBI investigation into the massive Chinese spy ring that China has at our colleges and universities that conduct research, where American taxpayers subsidize this research and development, and Chinese students steal that technology, steal that information, and send it back to China. Every American should want that stopped, but Joe Biden ended that, ended the FBI's investigation into that with someone who's received tens of millions of dollars from China, just like Joe Biden. That is a bad decision for the American people. That puts China first and America last. Then you look at what all happened with Burisma, with firing the prosecutor. That we've talked about that in the past. But I think you're going to see more and more evidence come forward that Joe Biden had a lot more knowledge about Burisma than what he's ever claimed. So I think that we're now at the phase of the investigation where we've accumulated enough bank records to where we can ask these IRS employees specific substantive questions and now bring the people in for depositions and say, what triggered this wire transfer from China? What triggered this wire transfer from Romania?
Nice.
And why did you launder it through all these shell companies? Why didn't they just send it directly to the Bidens? We're going to be able to answer those questions publicly to where every American can see it.
Good news. All right. So James Comer, long road ahead. This is a complex network of crimes from the Biden crime family, slowly but surely making some progress. And we know that the whistleblowers will be testifying for all of America to see. And of course, we're asking ourselves, what does Kevin McCarthy, the Speaker of the House, have to say about all this? Because he can rally the votes and he can lead some efforts, let's say impeachment or something. Here is Kev.
Why would you wait to the statute of limitations when it came to Hunter Biden to the most serious problems and he would not be held accountable for that or pay taxes on that? And how could you move so fast if it's somebody you disagree with philosophically, like a President Trump, and you could move real quick to indict there? The equal justice is a defining moment of this nation. We know over at the Supreme Court, you got lady justice there that has a blindfold and a scale that's supposed to be equal. Everything we have watched from this point forward, they treat people differently based upon their political beliefs. And that is wrong, and we're going to get to the bottom of it, and we're going to stop it.
Some people sit in solitary confinement. Other people are bailed out by the vice president. So Democrats now want Republicans who are even asking questions about their side, who are bringing whistleblowers out to light. They want them investigated. And it is the chilling of speech. It's, in my opinion, a direct threat against other congresspeople. It's Rep. Garcia, Rep. Comer, directly threatening James Comer because they have been able to unearth something damaging for their side. So things will continue to escalate. We'll continue to follow. All right, my friends. And lastly on the day, Mark Zuckerberg gets a congressional letter from Jim Jordan, the chairman of the House Judiciary Committee, as the elections heat up, as the political battles take place on the ground and also in the digital space. We know that there is a battle for our minds. We've got Twitter being bought by Elon Musk and freeing up a lot of the battlefield for 2024. But Mark Zuckerberg also launched a new competitor called Threads, and it was supposed to be this much safer, less racist, less violent, bigoted platform that Twitter has become, allegedly, under Elon Musk's stewardship. And so we know that Jim Jordan is upset about some of the censorship that has hit the new platform. And if you've been following along on Twitter or elsewhere, yours truly did not create a Threads account because we're loyal here. But we have a history of seeing other conservatives who did appear on Threads just to poke around over there to see what happened. They got censored. They got thrown off of the platform immediately. They post something about Hunter and they're gone. And there were a bunch of conservatives who just tested the limits. They got on there, posted a Hunter pic, and boom, censored immediately. So we expected that. But what is also funny is they're censoring Taylor Lorenz too. In fact, she's a writer for the Washington Post, and she posted this. She said, second community guidelines violation in less than a week. How are we supposed to discuss or talk news stories and the media when Instagram censors it? Other people posted this exact screenshot, got no violation. This is so ridiculous. I'm now in danger of losing my Instagram account now. Oh, somebody cry her a song. Give me a break. Yeah, it sucks, doesn't it, being censored? It sucks getting hit with a strike on YouTube or getting your accounts banned. Why don't we all just speak? Just allow everybody to just speak. And so she was one of these people who ran over to Threads and, thought it was going to be the grass is greener over there. Now she's about to lose her whole Instagram account. So, oh, boo-hoo-hoo. Now, the Threads usage is actually plummeting, apparently. This came over from Complex. It says that Meta's Threads is already seeing a decline. The new platform has seen a decline among subscribers. Opened with a boom, got 100 million signups because they basically bootstrapped it to Instagram and to Facebook. But it's down. Number of active daily users down 20% from Saturday. And the time people spend on the app also went down 50%. Because when you can't talk about controversial things and can't speak freely, you have a boring, dull platform that is not useful. And so this is why I constantly will say these people's visions for their utopias are all going to collapse upon themselves because they are just not as interesting. It's just not as interesting as some of these other things. So their numbers are down. SimilarWeb also showed downward trends for Threads. It's all going downhill. Meanwhile, Twitter's looking pretty good because they're paying out big money. And what was so funny about this is Taylor Lorenz was complaining about Threads and Instagram censoring her. But then she writes this article about how Twitter is paying out a bunch of the right-wingers. Far-right Twitter influencers were the first on Elon Musk's monetization scheme. And if you were around over, I think, the weekend, a bunch of creators were getting big fat checks for posting all over Twitter. The platform is paying high-profile creators, including people like Andrew Tate, and Tucker Carlson is just signed a new deal on Twitter with an advertising platform on Twitter. Thousands of dollars went out. And so on Thursday, Twitter announced it would begin sharing ad revenue, but it's not going to apply to all creators. Some people dropping big donos or getting big checks from Twitter. $10,000 from End Wokeness. Whew, that's a nice one. Andrew Tate got 20 grand off of there. DC Drano apparently posted something. Libs of TikTok didn't share her post, but a bunch of people got paid on Twitter. And so poor Tay-Tay is very upset about this. She's not happy that she is not part of Elon's inner circle. Oh, she's so upset. But Jim Jordan is sending a letter over to Zuckerberg because this is actually serious business. We've got an election coming up. We know that Facebook was infiltrated by the FBI. He explained that on Joe Rogan's show, saying that they got censored more or less by the FBI. They came in and said, we're the FBI, Russian disinfo. I'm like, okay. And so they all did it. And now Jordan is concerned that they're going to do this again. And maybe this is just a giant honeypot. All of the, the big intelligence. One theory is they no longer have access to all of the data on Twitter. You can't scrape it anymore because of rate limiting, and you really have very limited reach or ability to interact unless you're paying the blue check for the blue check at the $8 a month. So, or bot it, in other words. You can't bot it to death like the federal agencies probably were doing. So now Zuck creates an alternative to capture that need, and Jordan is sending a letter demanding answers about their censorship. This one went over to Mark Zuckerberg, care of his lawyers, Kirkland and Ellis, over in Washington, D.C. Coming from Jim Jordan, chairman of the Committee on the Judiciary. He writes the following. Dear Mark Zuck, hey Mark, the Committee on the Judiciary is conducting oversight on how and to what extent the executive branch, Biden, has coerced and colluded with companies and other intermediaries to censor speech. In furtherance of this oversight, the committee on February 15th issued a subpoena to you compelling the production of documents related to the content moderation and Meta's engagement with the executive branch. We wanted those docs. In light of Meta's introduction of a new platform, Threads, we write to inform you that that subpoena covers new material related to Threads. We're just going to expand that puppy. Since you're launching something new, we'll take a look at that too. They say, since the committee, Jim Jordan writing, since we sent a subpoena to Meta, we have obtained additional evidence that the federal government has coerced or colluded with technology, social media, and other companies to moderate content online. These examples reinforce our serious concerns about whether Biden is engaging in censorship by proxy, using surrogates to censor, suppress, discourage speech in a manner in which the government is unable. On July 4th, in an incredible ruling by Judge Terry Doherty, a federal court held that the government's collusion with social media violated the First Amendment rights, and they told the government to stop. The court recognized that Meta played a role in this censorship scheme, and they constantly acquiesced and catered to the government's censorship demands. Jordan says, hey, Mark, Congress has an important interest in protecting free speech, and we need to develop legislation to continue to do that. And given the fact that Meta and your company has censored First Amendment protected speech as a result of the government agency's demands, we're concerned that you're going to do this again on the Threads platform. And Threads raises serious concerns because it has been marketed as a rival of Elon Musk's Twitter, which has faced political persecution from the Biden administration following Musk's commitment to free speech. In contrast, there are reports that Threads will enforce Instagram's community guidelines, which resulted in lawful speech being moderated following pressure by the government. Despite launching only 12 days ago, there are reports that Threads is already engaging in censorship, including censoring users, but offering no grounds for appeal. Poor Taylor Lorenz. Oh. The committee's February 15th subpoena to Meta requires, among other things, conversations with the executive branch. The subpoena is continuing in nature, meaning you got to keep it updated. And thus, to aid our oversight, we ask you, please produce all of the other information we requested previously, but this time, just apply it to Threads. And don't forget, this letter is a preservation letter. You better not destroy anything. Construe this letter, meaning you do not intentionally or negligently destroy anything. We are the House of Representatives. We have the right to investigate you according to H.R. 12, and that's exactly what we're doing. If you have any questions about it, let us know. Sincerely, your friend, Jim Jordan, Chairman, House Judiciary Committee. So we'll see what Mark does. We know they are actively censoring people over there because that's just how they live and operate. And they have also explained that they disfavor news silos in the first place. And so we'll see. We have the self-sorting well underway. People continue to move geographically to different locations. People are sorting themselves into new internet platforms. People are buying products now associated with their ideologies, their beliefs, their values. And we just continue to separate apart. We're going to see how this unfolds in the next election. Congress is going to continue to keep a watchful eye. So will we as we carry on. Thank you, my friends, for subscribing wherever it is you're watching this. We look forward to seeing you on the next one. All right, my friends. That is it for the day. We covered some good ground. Zuckerberg gets another letter from Congress. We'll see what he does with it. Democrats want James Comer, their colleague, investigated now for calling them out. Democrats warning us there's another coup coming. We're all going to die again. January 6th, defendant Edward Lang is appealing to the Supreme Court. We hope he's successful and we get some clarity on that. And we know that the Trump prosecutors want a protective order so that Trump's defense is very nice and limited as they go through the classification documents. But now, my friends, let's see what you have to say about it. And I saw a couple of very nice super chats come in on this lovely day. And I'm very grateful for everybody who supports us and the work that we do here. Big shout outs to our friends who became supporters at the start of the show. You can join on YouTube. You can join on Locals. Wherever you join, we appreciate it. We do members only morning streams. We hit the Trump docket. We hit the presidential schedule, the committee schedule. We have a lot of fun. And big welcomes to Patrick Parker, Glenda in the house as a member, Timothy Teeter in the house as a member. Very grateful. Thank you for joining up. And Waldo sent in a nice message, but no question on that. Thank you, Waldo. Waldo's been a member for quite some time, and we appreciate Waldo in the house. Let's see who else we've got. That was from Waldo. Patrick Swagger's here. Also became a supporter. Man, we're getting some good supporters here today. Super fun. And so don't forget, our members, we do morning streams in the morning. See you tomorrow, Patrick. 2012 Jameson says, I wonder if Nixon versus U.S. in this case can be used to limit in these now classified documents case. Also, opinions are not defamation or criminal acts. Some good stuff there from 2012 Jameson. And I'm personally looking forward to just some filings from Trump. I can't wait to see what direction they go. And we'll see very soon. We might know some more on this tomorrow after the hearing takes place. Hey, Hunter's Crack Dealer is in the house. Says, Rob, I'm writing you this as I'm lying here dead. Oh, that's too bad. That sucks. It's kind of cool you can write, though. Just for the record, it's Trump and his lies that killed me. Oh, well, I mean, what else is there? That's the leading cause of death for men and women over the age of 3. Trump, the leading cause of death. It's true. Gotta go. They are getting ready to bury me soon. I'll write later after the burial. By the way, I'm not identifying as dead. I'm just plain dead. All right. So, well, there you go. Another Trump casualty out there. Just dropping like flies out there. Well, hopefully you enjoy the rest of your eternity, John Allen. Rest in peace. Passport Bro is here. Says, I heard the bag of cocaine had Hunter Biden written on it. Yeah, he labeled it. Hunter's Coke. Return to Hunter. Puts his phone number on there, 602, whatever. Yeah, wouldn't be, cocaine's expensive. Michael Allen Hughes says, just ignore the laptop. Republicans have nothing. I don't know. We'll see what they're able to uncover. I think they have something. The question is, are they going to be able to get it out and get it into the ecosystem, into the mind's ecosystem, ecosphere of the majority of Americans? Because they still control a lot of the levers of informational supply chains. I still find it amazing. I still talk to people sometimes and I'm like, you don't know that the Russian thing was like A hoax? What? Like, I know, I thought he colluded with Russia. Like, oh gosh. You know, it's just like painful. So who knows if it will break through the zeitgeist. We'll see. Horatio Spinelli says, long live Anonymous. Good to see you, Horatio. They do good work. I would never say anything bad about Anonymous. We have Horatio Spinelli says, long live freedom, baby. Certainly can get behind that one. Good to thank you for both of those, Horatio. Horatio, I appreciate you, my friend. Vince J says, hey, Robert, thank you for what and all you do. Well, thanks, Vince. And thanks for joining us, my friend. I really appreciate you watching us. I appreciate you being here, and I appreciate this tip. Looks like you have a very, very handsome puppy there as well on your screen. Thanks for being here, Vince. Hey, C. John, bringing in 5 new membos. Love that. Thank you, C. John. Who's coming in? We got Third Proverb. Nunya Bitness is joining us. Scott Ross, Mark Gibson, and One Nation Underground, all coming in courtesy of C. John. And so thank you very much, C. John. And welcome aboard, new members. We'll see you in the morning. Should be a lot of fun. We got Salty Sarge in the house. Says Threads icon has 3 6s. It's 666. It's the Mark Zuckerberg sign of the beast. I noticed that, actually. Yeah, I did notice that. I saw that almost immediately. I was like, that's curious. And then I've seen that in a couple other spots too. Like once you start seeing it, I saw it. Somebody else posted another logo. It was a building or something. Yeah, it was a curious, right? It's the threads. It's like threads, like threads, but it like threads, like a bunch of 6s. Very curious. Hey, FMF Doc says, hey, Rob, did the Bidens receive money from China while President Trump was in office and enacted the China policy, which the Biden administration struck? Yes. So I think that some of the allegations were from when Joe was VP, and then some of them were in the immediate aftermath of his VP, of being VP. So like the Ukraine prosecutor was while he was VP, although I think some of the CEFC stuff might have been after he was VP, which was struck when he actually won the presidency after the fact. I think that's the timeline. I could be wrong on the timeline. It's a lot of dates, and I get confused on the dates. But hey, American Dreamer, and first of all, thank you for that, FMF Doc. Very nice. Thank you. American Dreamer says, Rob, say hi to Trisha. What's up, Trisha? How are you? Hopefully you're having an amazing day. Thanks for being here and joining us. And thanks for everything. And shout out to Trisha and American Dreamer over at the American Dreamer household. Good to see you. And shout out to Trisha for being here. Woo! We love our Trishas in the house. And Steel Stargazer says, here's a big kissy for your hard work. Well, that's really nice of you. Wow, I'm flattered. Woo! Am I blushing? Oh my goodness. This show. It's getting a little steamy in here. Woo! All right. Thank you, Steel Stargazer. And Trust2Kids says, thanks for another great show. Thank you, Trust2Kids. And thanks for joining us over on Rumble. And shout out to our Rumble friends. We have a growing chat in Rumble. And shout out to our friends. Dog Digger, Indoctrination, Southie31, Paul Blart's over there. Thank you, Paul. Jan X in the house, Southie31. We got some good chats over there. Paul Blart says, come on, man. They like to touch my hairy legs, so stuff like that. So shout out to our friends over on Rumble. We're going to check the Twitter sphere in a quick minute. This is Hunter is this is coming in from Geegum Geegum. I'll pull up the full COVID molecule. This is Hunter is just faking his death to increase the value of his art. If I had to buy one of his pieces, it would be this one. And that's the COVID. Hunter Biden's paintings look like COVID. And this is the Rob COVID molecule. This was made in a lab in Arizona. Yeah. It's very deadly. Very deadly. It's not good. You definitely don't want to experience this COVID. It's bad. It's called the Rovid. It's the Rob COVID. It's bad. You don't want to deal with it. Anyway, so thanks for that, Geegum Geegum. It's a good plot. He could be plotting to increase the value of his art. We never know. Geegum Geegum, our meme smith extraordinaire. Eddie Oliver says, Rob, I'm asking you and your role as an attorney. If, hypothetically, Eddie is asking, if I were to rip out somebody's still beating heart and show it to them, Can I claim self-defense? Not sure if you can do that in Arizona, but we can in Texas. I think that's the Indiana Jones rule, no? Didn't that happen in Indiana Jones? And maybe also like Wayne's World, the second one? Yeah. I think it's valid. I think you can do that. As long as they attacked you first, Eddie. If they attack you first, then you can just and rip it right out. Thunk, thunk. Yeah, okay, this show just got rated R pretty fast. Thanks, Eddie, for that one. But shout out to our friends in Texas, where you can rip hearts out, like on Indiana Jones. All right, my friend, a lot of Indiana Jones analogies here lately. I haven't even seen that movie in a long time. But maybe we were talking about on Locals this morning, the Indiana Jones head, the golden head. Like maybe who's going to be, we've got Joe Biden right here. Who are they going to remove him and replace him with? Is it Michelle Obama? Is it Gavin Newsom? What's it going to be? We don't know, but could be somebody. So that was our other Indiana Jones analogy. Let's say hello to our friends on Twitter, where we have a whopping, oh my gosh, 4 viewers. It's out of control over here. If you're going to come over here to Twitter, make sure you can tolerate massive monster crowds, because it's just a little bit nuts. Hey, Fred Pedamonte. Hey, Fred is here. He says, Johnny would not stop watching you. This is Johnny. Real good boy, Johnny. We did a walk and talk over the weekend. And if you missed that, you can certainly catch that. But we did a debrief on the Tucker Summit. And so that is Johnny boy watching the good old walk and talk. He probably wants to get outside and get a little walk in himself, is I think what I'm looking at. Fred says, can the defense make the same motion for the prosecution? Can the defense make the same motion for for like a protective order? I don't think so. No, because it's the law grants the government the right to request it. And the government would have the interest, the standing to make that claim. So like, it's a standing issue. The government sets the law. They say we have the authority to protect these documents, and so it's theirs. There's a question here about, is anyone else having problems with the members-only shows on YouTube? Let me know if you are. I mean, hopefully not. We did one this morning, and I don't think anybody had any problems this morning. We had some people in the chat, and it worked this morning. But send me an email if you're having problems, robert@spotlightlawyer.com. I'll see if I can help you out. Al Holman says, the truth, Democrats are sore losers 2016, and they still haven't gotten over it. I think that's right. They're still mad, and they're just taking everybody out. Hey, Dr. Hello is in the house. Hello, Doctor. Says, all Republican court. I love how Trump uses his donors' money for this. Is that a comment to me? For this frivolous BS. What is this? The Georgia Supreme Court just unanimously rejected Trump's bid. Well, I don't know that it's a waste of money. I mean, I think Trump is exploring his legal options. It would be my take on it. I mean, you're allowed to, file stuff. And I don't think it's frivolous. I think that he should be filing these things. But it's a fair point. Maybe he's filing a lot of other stuff, and you think that maybe he should be more tactical about where the money's going. I can see that. Jeff says the smoke from Canada is all the way to the Gulf Coast. Doesn't Canada know secondhand smoke will kill you? Jeff B. Yes, Jeff B. Salty Sarge says Temple of Doom. That's the one I was thinking of. That's where he pulled the hearts out. It's kind of a traumatic scene. I remember that. I was a kid. I was like, what is happening? Well, this is pretty rough. But, okay, my friends. So, those were our friends on Twitter. Hello to our friends on Twitter and Rumble and all of the other free speech platforms. We are going over for our members-only after party at watchingthewatchers.locals.com. And we would love it if you joined us. We do a lot of extra member-only stuff. We try to get member-only morning streams done so we can be properly situated on our days. And so come and join us, watchingthewatchers.locals.com, or join us on YouTube by clicking that join as a member button. We'd love to have you. Also, don't forget to grab your Field of Greens, courtesy of our friends at fieldofgreens.com. It is good stuff. It does taste good. I do drink it. And if you look at the ingredients on the back of your label, you'll just see what I'm talking about. You just go, oh, duh, I'm not getting any of that stuff. And so it's good and useful. And you can save 15% off with code Robert when you check out. We also have a mind map. If you like this software that I use and you want to play around with it or create your own account for free, you can do that. Go to spotlightlawyer.com/mindmap and sign up at your heart's desire. We also want to thank the mods and the meme smiths who mod down the fort for us and keep things nice and beautiful and situated on the day. And so big shout outs go to our friends Vienticus Prime, K Bean in the house, Just Cause, our friend Playin Hooky, Ronnie Cole, Zulu, Beyond Geostars, Zach Nichols, John Allen, Janek 909, Dog Digger, Donut Mind Me, our friend Sleepy Dog Lee, Geegum Geegum, and Nathan N810, our meme smiths over on Locals. And my friends, that is it for us. We appreciate everybody who helps make this show possible to keep the train nice and tidy and on the tracks. But we are done on the day. We are going over to Locals, our members only after party. We'd love it if you joined us. But if not, well, we'll be back here tomorrow to do it all again. All right. And we've got a proceeding with Judge Eileen Cannon and Donald Trump. And I'm sure there will be business to attend to there. I see 2012 Jameson just sent in a final super chat before we wrap it up on the day. Says, standing is for lazy judges. Judges are also political. Roberts is the new Tawny. Yeah, standing is kind of that catch-all. Well, you don't have standing on that. You don't have standing on that. You don't have standing on this. And then the whole thing gets dismissed. And I didn't read the Georgia opinion, but was it a standing dismissal? That would make sense. So, all right, my friends. Well, that is it for us. We are going to go over to our after party. We'd love to see you. But if not, we'll be back here tomorrow to do it all again at the same time, at the same place. We'd love to see you here. Thank you for subscribing. Thank you for bringing a friend over, telling them, hey, we've got this live stream that we do. We have the best chat on the internet. And so, maybe they'd like to partake in it and, learn a little bit about some of the insanity going on in our world. We'd love to have them, and we appreciate you bringing them along. But that is it, my friends. We will be back here tomorrow to do it all again. And I hope to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.